Hello everyone, I'm Alex Grant and welcome to Immigration Update Desk. If you've been following U.S. immigration developments lately, you've probably heard a lot about travel rules, enforcement, and new screening practices, but a quieter and potentially more consequential shift is coming into focus as we move through 2026. Multiple compounding policy choices are projected to reduce the total number of green cards issued over the next several years. And the scale of that reduction matters for families, workers, students, employers, and communities that depend on predictable legal pathways. A new analysis from the National Foundation for American Policy, NFAP, a nonpartisan research group that studies legal immigration trends, estimates that, compared with recent historical patterns, between roughly 1.5 million and 2.4 million fewer people could receive lawful permanent residence by the end of the current presidential term, which is not a technical footnote but a restructuring of the flow of legal immigration, because permanent residence is the cornerstone that turns temporary stays into long-term lives, unlocks career mobility, stabilizes families, and ultimately funnels many immigrants into citizenship. To understand why this projection is plausible, you have to look at how different pieces stack. Legal immigration is not one faucet but several: immediate relatives of U.S. citizens, family preference categories, employment-based categories, refugees and asylees adjusting, and the diversity visa (DV) program, and NFAP's modeling points to large dents in more than one stream at once, with the biggest absolute numbers falling in the immediate relative group, even though it is normally uncapped, because admissions are being throttled by stricter screening, especially around financial sufficiency or public charge determinations, consular pauses or slowdowns for certain nationalities while reviews are conducted, and tighter documentation requirements that, taken together, reduce the rate at which approvable cases actually convert to visas and entries. The report estimates that between about 941,000 and 1,654,000 fewer immediate relatives, spouses, parents, and unmarried children under 21 of U.S. citizens could become permanent residents over 4 years than would have under recent norms, which is striking precisely because this category traditionally bypasses numerical caps and moves whenever the paperwork is ready. Another big driver is refugee policy. Public sources and NFAP's analysis point to a markedly lower admission ceiling and operational capacity, and if ceilings and processing run at those levels across multiple fiscal years, the cumulative result could be roughly 470,000 fewer refugee-based green cards by the end of the term. Add to that the diversity visa program, which in a normal year contributes about 55,000 new permanent residents selected from countries with historically low immigration to the United States, and which, if suspended or significantly reduced for 1 to 3 years, as some reporting indicates, could subtract another 55,000 to 165,000. Stack these losses on top of slower family and employment adjudications, additional security screening that lengthens timelines at consulates, and a more cautious use of discretionary approvals, and you get a plausible path to the upper end of NFAP's up to 2.4 million fewer projection by January 2029. It is important to be exact about what this conversation is and what it is not. We are talking about legal immigration through established channels, people filing I-130s and I-140s, refugees vetted through formal pipelines, DV selectees with case numbers at Kentucky Consular Center, not about unauthorized border crossings or interior enforcement against the undocumented, and the mechanisms at issue are administrative choices, pauses, ceilings, documentation standards, screening policies, layered on top of statutes that Congress has not rewritten in the past year, which means these numbers could shift if courts, Congress, or future policy memos change inputs. But in the near term, families and employers have to plan for a leaner flow. To see how this lands on the ground, take the family-based stream that supplies the largest share of green cards in a typical year. Immediate relatives of U.S. citizens have historically moved fastest because there is no numerical cap. Yet in 2026, this group faces heavier document scrutiny at both USCIS and consulates. I-864 affidavits of support are examined for current income and household size that match the latest I-864P guidelines. Tax compliance is checked via IRS transcripts. Proof of U.S. domicile is weighed more carefully for petitioners living abroad, and public charge-related guidance, while grounded in long-standing law, has been enforced with more emphasis on present capability and consistency across the record. On the consular side, many posts have operated under instructions to pause immigrant visa issuance for certain nationalities pending screening reviews, which means families make it through petitions, NVC documentarily qualified status, and even interviews only to see visas not printed yet. For preference categories that already wait on the visa bulletin, that last-mile choke point lands on top of priority date arithmetic, compounding delay. The immediate human result is that people who played by the rules for years are pushed into another round of waiting, with real costs in housing, jobs, childcare, and mental health. Employment-based immigration feels different too. While EB numbers are governed by caps and spillover rules and may be less directly affected than family immediate relatives, the 2026 environment is costlier and more documentation-heavy. Perm recruitment and prevailing wage steps carry higher fees and longer lead times. H-1B and I-140 filings face more pointed RFEs on specialty occupation logic and degree relevance. Premium processing helps at specific stages, but does nothing for consular stamping if posts are backlogged, and administrative processing, 221G, after interview is more common for certain profiles. All of this does not mean no to skilled immigration. It means prove it with clarity. And companies that manage pipelines by starting earlier, aligning wages and duties with SOC codes, and planning stamping buffers do better than those that rely on last-minute heroics. The knock-on effect of a smaller pool of new permanent residents is felt not only in Fortune 500s, but also in hospitals, labs, startups, and public sector projects that recruit internationally, and universities that once advertised clear long-term pathways to prospective students now have to advise cohorts about tighter gates and the importance of early employer sponsorship rather than assuming automatic stay options after OPT. Refugee admissions tell a different but complementary story. When ceilings are cut steeply and operational capacity shrinks, it takes years of investment to rebuild the pipeline of referrals, interviews, medicals, and travel, so even a future policy reopen cannot retroactively fill multiple years of missed admissions. Communities that built resettlement infrastructure, language programs, mental health services, employment networks have to scale down, and families separated by conflict wait longer for reunification through derivative or follow to join paths. While some categories of humanitarian parole have expanded episodically, they do not substitute one-for-one for refugee to LPR pipelines because the underlying legal pathways, benefits, and timelines differ. NFAP's projection of 570,000 fewer green cards through refugee admissions over 4 years is plausible because every year of a low ceiling ripples through future LPR adjustments. The diversity visa program is always a small share of total LPRs, but it plays an outsized role in geographic diversity and individual life chances. For many selectees, it is the only realistic legal door given per-country family backlogs or lack of employer sponsorship. If DV runs at 0 or reduced numbers for 1 to 3 years, that alone subtracts tens of thousands of future residents and changes origin country mix in ways that are hard to rebuild quickly. DV's tight fiscal year deadlines also mean that administrative delays are not harmless. They cancel numbers when cases cannot be issued by September 30th, and canceled numbers do not carry over. So operational pauses translate directly into fewer permanent residents. What does this mean for applicants and sponsors in practical terms? First, recognize that the system is not closed, it is tighter and slower, which means preparedness and precision matter more than ever. For consular families, keep civil documents exactly aligned with the State Department reciprocity table. Use IRS transcripts for sponsors, calculate household size and poverty thresholds correctly, and keep passports and police certificates valid through extended waits. Respond to NVC checklists and 221G requests with precisely what is asked and nothing contradictory. For those physically in the United States who are eligible for adjustment of status, consider whether AOS is the safer path in a world where consular issuance is paused for your nationality. File I-130, I-485 together where allowed, include or time the I-693 medical strategically, and renew EAD AP early. For employment cases, audit job descriptions, SOC codes, and wage levels before filing, plan stamping, timelines by checking post-specific wait times, and prepare for administrative processing by carrying petition copies, employer letters, and project documentation. For students, maintain SEVIS accuracy, keep travel signatures fresh, carry funding and enrollment proof, and plan around OPT, STEM, OPT unemployment limits. These actions do not change macro policy, but they place your case at the front of the line whenever a gate opens. Second, recalibrate expectations about the visa bulletin and spillovers. Movement will be uneven across categories and countries, and a family category that looks frozen today can move if immigrant visa arithmetic shifts in later fiscal years. Because you cannot control that arithmetic, convert waiting into readiness. Keep your NVC account tidy. Rescan old uploads at legible resolution. Set calendar reminders for document expirations, and build a Go packet so you can accept an interview on short notice. Third, understand how public charge plays out in 2026. The core test is about primary dependence on certain cash benefits, but in practice, officers are looking for a credible financial picture, steady income, tax compliance, and real domicile. So sponsors abroad need to document their return plan with job offers, leases, and school enrollments rather than only declarations. If income is short, secure a qualified joint sponsor and submit a complete I-864A if household. Members' income is counted. Asset counting helps in narrow cases, but requires clarity on ownership and convertibility to cash within a year. Opaque financials invite delays. Fourth, travel and border planning deserve new attention. Integrated entry-exit data means officers can see patterns clearly. And while most travelers pass quickly, those with repeated short trips that look like de facto residence abroad, ambiguous employment stories, or mismatches between visa class and activities will get questions. Carry a small set of documents that aligns with your purpose. Return tickets, conference invites, employer letters, proof of funds, and keep your answers short and true. If you are adjusting status, do not depart without approved advance parole unless you are in H or L status and traveling under those carve-outs. If you are a green card holder spending long periods abroad, obtain a re-entry permit before departure and file U.S. taxes as a resident to avoid an abandonment narrative. If you have any criminal history, carry certified dispositions and consult counsel before international trips because many state expungements do not erase immigration consequences. Fifth, expect more secondary inspection and more administrative processing for routine reasons. Secondary is a workspace, not a punishment, and Patience Plus prepared documents move it along. Administrative processing after a consular interview usually means name checks or missing items, Respond exactly as instructed, and mark your calendar for polite status checks at rational intervals. Flooding posts with daily emails hurts, it doesn't help. Sixth, zoom out to the economic and community dimension. Fewer permanent residents over 4 years means slower population and labor force growth in communities that depend on immigration to stabilize school enrollment, support elder care, and fill specialized roles in healthcare and technology. Employers will have to develop domestic pipelines more aggressively while still using employment-based immigration strategically. Universities will need to be candid with recruits about post-graduation options and the importance of early sponsorship. City planners will need to adjust growth assumptions. None of this is apocalyptic, but it is a different curve than the one most stakeholders planned for a few years ago. Finally, accept that while statutes remain the backbone, administrative choices are driving today's reality, which means outcomes can change mid-journey if courts enjoin a rule, if a future memo restores guidance, or if a new ceiling is set. In a world of moving targets, build resilient plans. Keep your documents immaculate, your expectations realistic, and your timelines flexible. Use primary sources, agency policy alerts, Federal Register notices, consular pages to verify any viral claim. If your situation is complex, invest in a tailored legal consult rather than crowdsourcing high-stakes decisions. And if you're tired of waiting, convert that energy into readiness. By the time the system shifts again, you want your case to be the easiest yes on an officer's desk. Immigration Update Desk will keep reading the source material, comparing it with on-the-ground reports from families, attorneys, students, and employers, and translating it into steps you can take the same day. Until then, remember that legal pathways still exist, even if fewer green cards are projected overall, and that clarity, preparation, and patience are the best tools for navigating a cautious year without letting uncertainty take over your life. Thank you for staying informed with me at Immigration Update Desk. And if you're in the middle of a green card process or mapping one out for your family or company, use this moment to audit your file, align your evidence with today's standards, and build small buffers into your timelines. Those practical choices are the difference between feeling stuck and being ready the moment doors reopen.